Alright, it is time for the MRX versus Jukin Media follow-up, answering questions in the comment section and addressing some of the comments time. That is a long intro to a video. Viva Frei, Montreal litigator turned YouTuber, and in my most recent vlog, I addressed this controversy, this copyright controversy that's going on between MXR Plays and Jukin Media. If you haven't watched that video, I'm going to link it right here. Give it a watch before watching this one, obviously, so that this video makes sense. The bottom line of the scandal is that Jukin Media, a video licensing agency, has gone after this channel called MXR Plays and gone after them hard. They've gone after them for alleged copyright infringement for doing reaction videos to material over which Jukin either owns the copyright or manages the copyright. And Jukin Media has sent MXR Plays something like 4 invoices for $1,500 each, saying pay up or we're going to file a DMCA takedown notice. And the situation has exploded on the interwebs and on social media. People are suggesting that what Jukin is doing qualifies as extortion. And then the question is whether or not what MXR Plays is doing actually qualifies. Yes?
I'm making you a tie-dye shirt.
Booyah! And then one of the other questions is whether or not what MRX is doing qualifies as fair use or is in fact copyright infringement. A bunch of people have shared their thoughts on the subject, including internet lawyer Leonard French, who's done a great job on it. I've shared my thoughts for what it's worth. I don't think it's a black and white situation. I don't think it's cut and dry, and I don't think both parties are entirely in the right or in the wrong. But reading through the comment section of my vlog on the subject, I've noticed comments addressing the same issues, and I think it might be very good to address these comments in a follow-up video. Now, I know a ton of you are probably going to take issue with this, but for the purpose of this follow-up video, I am going to be operating on the basis that the use MXR is making of the videos in question is not fair use. I know a ton of you are going to take issue with that assumption because that is one of the very questions at issue. But it is always going to be a case-by-case question of fact and law whether or not someone's use of a video qualifies as fair use versus copyright infringement. And it is not a question that we are going to be able to answer on a case-by-case basis or on a global basis. It is arguable as to whether or not the use that MXR Plays makes of the videos to which they react qualifies as fair use. In order to determine whether or not the use qualifies as fair use, it does in fact require a judgment of the court. And I know a ton of people are referencing the H3H3 judgment, in which it was determined that 3 of the 4 uses H3H3 made of certain material qualified as fair use. As far as I understand, 1 of the 4 uses at issue did not qualify as fair use, and that was done after analyzing all the factors and applying them to the situation at hand. So we are simply not going to be in a position to determine whether or not the use that MXR Plays makes of videos to which they react qualifies as fair use. So this entire response is going to be based on the assumption that they do need authorization in order to reproduce the work that they are going to use, because it does not otherwise qualify as fair use. And regardless of whether or not you take issue with this premise, the bottom line is if you are walking the line, or if you are unsure, you ought to get permission before reproducing someone else's original work. So let's address some of the most frequent questions raised in the comment section. The first of which, I have been accused of misrepresenting MXR Play's position in that I didn't include the portion of their response video where they talked about how they offered to Jukin Media to review their material to make sure it didn't contain any of Jukin's videos before publishing it to the internet.
And then the first time too, we were like, okay, fair, just to make sure that we don't use your clips, can you check out our video and tell us if we used your clips? And they're like, no. That is so clearly like they don't want to work with us.
I didn't address that specific issue because I didn't want to look like I was picking on MXR Plays, but the reality is that is not a realistic proposal. Imagine what MXR Plays is actually suggesting here. They're going to send their videos to Jukin so that a representative of Jukin can review and vet and approve their videos before MXR Plays publishes them. And imagine if every other content creator on the platform asked Jukin to do the same thing. It is not Jukin's responsibility to make sure a content creator has the rights to reproduce any given video. To the extent that the use a content creator is making of someone else's original work does not qualify as fair use, it is up to that content creator and that content creator alone to make sure they have the authorization to do so. And I know what some of you are thinking, well, Jukin has the ability to search its own databases more efficiently than a third party. Maybe, but Jukin is not in business with that third party, they don't work for that third party, and it's not their obligation in the first place. And it would shift the onus onto Jukin, every content creator on YouTube saying, Jukin, verify my video and make sure that it's okay so that I can publish it. But more important than that is the underlying fact that that question even presupposes. When MXR Plays proposed to Jukin that Jukin should look over MXR Plays content before they publish to make sure that they're not using any videos for which Jukin owns or manages the copyright, what that proposal implicitly recognizes is that MXR Plays doesn't have permission to reproduce those videos, period. Let's play out this thought experiment. Assume Jukin says, okay, we agree to review your videos to make sure that you're not making use of any videos over which we own or manage the copyright. MXR Plays sends Jukin the video and they say, okay, you're clear, you're not using any of our videos. That still implies that they are reproducing somebody else's copyrighted work without permission to do so. The bottom line is that if you are reproducing someone else's original work and your reproduction does not qualify as fair use, you just need to get permission. So even if Jukin confirms that MXR Plays is not violating Jukin's copyright ownership or management, to the extent that they didn't get permission from the copyright holder, they're still violating somebody else's copyright. If your reproduction does not qualify as fair use, if it is borderline, you just need to get permission. Which brings us to the next theme of questions that I've noticed, to the effect that sometimes Jukin only acquires the copyright ownership or management after the video has already been published. And apparently in certain circumstances, Jukin Media only acquired the copyright after MXR Plays had already published their reaction video. I have no way of knowing if these facts are true, but let's assume them to be true. A lot of you are going to be saying that this is a total injustice. Now Jukin Media is going after MXR Plays for copyright infringement when Jukin Media only acquired the rights after MXR Plays already published their video. And my response as a lawyer would be this: did MXR Plays get permission to publish the video in the first place? If they got authorization from the original copyright holder to publish the video and then Jukin subsequently acquired the copyright, it wouldn't change anything because they would already have gotten authorization. And I would totally agree that if the copyright holder granted MXR Plays authorization, then Jukin acquired the copyright and went after MXR Plays for copyright infringement, that would be a total injustice. I also think it would be totally unlawful because MXR Plays got the requisite authorization to reproduce the original work. But the bottom line is this: even if Jukin acquires the copyrights after MXR Plays published their reaction video, to the extent that MXR Plays did not get authorization in the first place and their use of the original work did not qualify as fair use, it is still copyright infringement. Point 3, if that's what we're on right now, a lot of you are saying that MXR Plays did in fact pay the $1,500 or $2,000 fee in the past, and that should apparently cover any licensing fee in the future. Indeed, it seems that Jukin, by its own admission, charges something like $50 a month as a licensing fee, and so if MXR Plays already paid $2,000, that should cover any and all future licensing. Now, don't confuse this observation for an approval in law of what Jukin is doing, but that $1,500 or $2,000 that MXR Plays already paid was a fee or a fine for past copyright infringement. It wasn't the $50 a month licensing fee that Jukin clients pay in order to have access to their database of videos. Which brings us to the next point as to how on earth Jukin thinks they can, in law, send someone a $1,500 invoice per infraction and think that the other party has the obligation to pay it. Now, I was pretty clear in my original video that this does, in my humble opinion, certainly get very close to walking the line of unlawful conduct for failure to use the E word. Some people rightly noted that the $1,500 fee that Jukin had unilaterally invoiced to MXR Plays was their penalty clause in their contract. And so the obvious question is, what obligation, if any, does a third party have to respect the terms of a contract to which they never agreed to adhere? If I had gotten that invoice, I probably would have responded, thank you for sending me an invoice for something that I never agreed to, but I'm just not paying it. Where Jukin's conduct walks the line between unlawful conduct is they say, okay, fine, I'm going to send you this invoice, knowing full well that there is no contract between the two of us, but if you don't pay the invoice, knowing that you have no contractual obligation to do so, I'm going to file a DMCA takedown notice, knowing full well that that might compromise, if not shut down, your channel. Potentially unlawful indeed. But to answer the question, what obligation does someone who is not a party to a contract have to respect the terms of that contract? Generally speaking, and I can't really think of any exceptions, the answer is none. Another comment that I noticed came up frequently is that MXR Plays tries to find the copyright holders of videos before they use them. And sometimes it's just impossible to find the copyright owner or obtain consent from them. What that is tantamount to saying is that I couldn't actually get permission to reproduce someone else's original work, so I just did it anyhow. If you can't get authorization to reproduce someone else's original work and the reproduction you are doing does not qualify as fair use, you just can't do it. It's not a defense to say, well, I couldn't find the person, so I just did it anyhow. It's not a defense to say I couldn't get authorization from that person, so I just did it anyhow. If what you're doing does not qualify as fair use and you don't have the rights to reproduce someone else's original work, you just don't reproduce that other person's original work. Find another video where you can reach the copyright holder in order to obtain permission. Find another video off one of the databases of video licensing agencies. But it is not a defense in law or basic equity to say, well, I can't find the copyright owner of this video to obtain permission, so I'm just going to reproduce it anyhow. A lot of people saying that copyright and IP law is outdated, it's not made to fit the times. When someone publishes something on YouTube, it's basically published in the public square and it becomes public domain. But the bottom line is that that's not the state of the law, and it's not clear that that would be a good state of law to exist at all. If it became the legal reality that by publishing something on YouTube, you basically put it in the public domain and lose all copyright over it, it would stifle YouTube and it would stifle content creation to begin with. When an author publishes a book, they don't publish it to lose all rights to it. And it's not because YouTube is not a pay-to-view system that publishing a video on YouTube is any different than publishing a book through a publisher. The very beauty of YouTube is that people get to create. They get to publish their creations to the world without losing copyright over those works. The creators nonetheless get to monetize their original works. When you publish your original work to the world, sure, you expose yourself to commentary, you expose yourself to parody, you expose yourself to fair use reproduction of your original work. But you don't expose yourself to wholesale theft of your original work, and to suggest otherwise would stifle all creativity on the platform. And people viewing this from MXR Plays situation also have to view it from the content creator's perspective. Reaction channels are content creators, I get it. But oftentimes what they do is make unfair use of someone else's original work to the point where nobody even needs to go see the original work anymore. For anyone who hasn't seen my viral video of the squirrel stealing a GoPro and carrying it up a tree, for a reaction channel to watch that video and react to it, even if they only watched 30 seconds of it, well, that video was only 1 minute and 15 seconds long in the first place. And the push and pull tug of war that you have here is effectively one content creator trying to make content and make money off their content, when that content exploits someone else's original work without licensing that original work. There are opposing interests to be balanced here, and I don't agree with what Jukin Media did. But the most straightforward solution to all of this would probably be just to have MXR Plays and all reaction channels, all satisfying compilation video channels for that matter, pay the requisite licensing fee to these video licensing agencies so that they can make sure they have the right to reproduce the videos. And it's not because a video is not being licensed by a video licensing agency that it's free to use. You still need to get the permission of the owner of that original work, to the extent that the use you are making of the video is not fair use. Now, abusive copyright claims, abusive DMCA takedown notices are an entirely different subject. But when a content creator is reproducing the entirety or a substantial portion of someone else's original work, the onus is on them and them alone to make sure they have authorization to do so. It's a balancing act. There are diverging interests. Intellectual property is property nonetheless, albeit intangible property. But if we shift the paradigm to one where if you post something on YouTube, you lose all copyrights to it, we are going to quickly see creativity die. My 2 cents, and I hope I addressed the most important of the comments in the comment section below. Let me know what you think. Drop some more comments here and I will get to them if they are new questions. If you like my videos, blah, 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 share my channel, help me grow, and now you know you vlog. Peace out. Booyah! Oh yes, and MXR Plays, Jukin Media. If you need a mediator, I am an accredited mediator. Compromise is indeed the best and cheapest attorney. I'm terrible at winking.